that the work we have done, and already we know, from the very word go, the public protector would have referred to this as an illegal, unlawful, irrational, invalid process. Many of those issues have been tested in court already and found in our favor. And so it is not to come here and just boast about that, but it is to say that when you stay the course in terms of your work, I think it's worth it at the end. I would be lying to say it was an easy task. I would have made an analogy of a pilot that the easiest thing for the pilot to do, difficult as it is to all of us, is to take off and land. But the most difficult task of a pilot is to manage the turbulence. And this process, in its DNA, were to manage that turbulence. At the head of that, I had to make sure that I do that against all odds. And I've thanked the members for being part of that process. Maybe I will pause there and allow you for any other questions that you want to ask.
Chair, now that the report has been adopted, what is the process now?
So yesterday, we, as I indicated, that the report is no longer our property. The committee has done its work. I'm hoping that the next meeting of the National Assembly Programming Committee would have that as an item, because that committee must now program the date, the venue, for when we're going to be voting for this report, the 2/3 that we need, because this is now about the removal of the public protector based on the work that we have done. We've made findings, we've given reasons, we've made our main recommendation to the National Assembly. And so when that date comes, we hope it will be here in September for the National Assembly to do that, because we don't have time. 14th of October is the last date. It has to be done, because it has to be in September, hopefully, because at the end of that, the NA must then submit a report, their decision, to the president, who must confine himself, because the president has no discretionary on this. The Constitution is very clear. Once the NA take that decision, he must sign off.
You responded to the letter of demand by
Well, the letter of demand that I've seen in the media space, in social media, by Advocate Erasmus has been sent to the Speaker. So Mr. Erasmus is asking the Speaker to remove the chair of the committee, or else that demand. It's not been directed. What was directed to me was the reconsideration of the recusal, which I responded to, which the committee responded to that. And so perhaps that question, the best person to answer that would be the Speaker, and I'm sure she would be able to respond to that.
Chairperson, what would you say is a major take? What was a major learning that you got from this thing? The process that you've spoken about, the turbulences and everything that went with it. What have you learned that you didn't know before you went into this?
Well, there's so many lessons. I think the first lesson is that I can speak about is exactly what we came here for here today. That when you do the appointment of the public protector, cover all the bases. If you are interviewing 8 people, get the best out of that 8. Don't go there with a preconceived idea as to who you want to. And I think we're doing that exercise. That's a first point. And inside there, we've been speaking about the evolution of this Chapter 9 institution. From 2007, when Kada Asmal released that report about why the need for these institutions to be put together and the need for them to be fixed. The irony is that today, as of yesterday, we're speaking about removing an incumbent, not even about the health of that institution. That's another lesson. But I think beyond that, the evidence that has come in front of us has really opened our eyes on a number of things, that it's important that institutions like these are protected even against themselves, against the manner they are run, the manner they do their mandate and so on. It's a key lesson that we're taking out of that, because we should not have been here. This is a public protector institution of South Africa, and an ombudsman that is supposed to be a beyond reproach. But the evidence that we've gone through about the kind of things that were happening there, whether it's about creating a consultant, appointing people who should never have been appointed and so on, are things that we would not want to repeat, to see again.
Talking of fairness and being patient, is the request from her new lawyers for a couple of weeks, was it just too much for you to accept?
Well, with the journey that I've tried to paint, that we have taken from the start of the actual inquiry, let alone the challenges that were there in court against the independent panel, the challenges that were there for this committee not to start, that went to the Western Cape High Court and to the Constitutional Court until on the 4th of February 2022 the Constitutional Court made that judgment. It is that judgment that really allowed it. So if you're speaking about the fairness and rationality, members would have said this, we're beyond reasonable, we're beyond fair. We went over backwards around this. And it's a lesson, because if we're to do the next exercise, we said we're going to have a meeting to take into those kind of lessons. There are certain things that we do not want to repeat. The length of this process cannot be repeated. And so anybody else who says this process was a rushed process, this process was a predetermined process, the entire country journeyed with us in this process. Everybody else, because we were led by evidence. We followed that, and even the outcome that we have made as a committee is based on that evidence. So if there's anything that, even if you wake me up, I can speak about with confidence, is the fact that we've been very patient, and we were tested almost beyond our limits around the issues of patience. So fairness is not one of the things that you can have a problem with in terms of this process. And that's exactly what we needed to give her. We needed to be rational, we needed to be fair to the person who account to the institution of Parliament.
Chair, a precedent has been set whereby previous public protectors were paid a handsome gratuity at the end of their term. Now, in the event of the current or the suspended public protector, in the event of her being removed before October, 1 month shy of her completing her term, would she still qualify for a gratuity?
That is a question that, just like the suspension question, that doesn't belong to us, because for us it's irrelevant. All we're doing our work. Those who must deal with pension issues must deal with that. It's not us. Those who needed to suspend her, suspended her. It was not us. We did not feature into that space. Our mandate was very clear. We tried to stick to that mandate under so many challenges. So I'm not going there.
On the bribery allegations, have you been contacted by the agencies made a statement, and also bring us to speed with regards to the ethics committee process?
Well, the ethics committee got in touch with me some time ago, and I responded to what they required me to do. As a member of the ANC, I would have accounted to the organization, whether it's through the integrity. I have not been contacted by any law enforcement agencies as we stand here.
What? Sorry, what advice would you give future Section 194 what?
The advice? There's plenty. There's plenty of it, I think, and I've been told. Firstly, we're told that this is a permanent committee, so I must give advice to myself first, if there's a next task that is coming. But for any future chairperson of this committee, Section 194, or a chairperson that is eminent to be there of a committee that would have to do an inquiry around the judges, or a chairperson that would have to do an inquiry in terms of Section 89 of the Constitution. It's really to stay laser focused on what your mandate is. Believe and stay on the facts and the evidence. They protect you against all sorts manner of things, so that you avoid any temptation because the important thing about this work is that you've got to take emotions out of yourself and navigate this space, because if you allow the emotions, you would not survive to manage that turbulence, and the landing might be very difficult.
You speak of some of the lessons that have been learned, and in the case of the funds that have been used throughout this entire process, do you reckon that it was all worth it, given the fact that you've covered how far this process has started and where it is, from the Office of the Public Protector, the funds coming from there, to the funds that were spent by Parliament in court, to the funds that have been spent by Parliament during the proceedings themselves, a combination of all of the funds that went into the process and the duration thereof? Was it worth it?
Maybe I need to break that up. So I think for Parliament, the National Assembly, from the very beginning, I made the point that this exercise, which is about oversight and accountability, enhancing democracy, is priceless. Because it's important that we do this work, that you cannot put a price to it. So that you have a healthy institution, you have a healthy democracy. Doesn't mean that you've got to be go overboard, but it's important that that is understood first. The second part of it is that not everything else that in this process can be regarded as priceless. To give you one example, I've mentioned yesterday that you have a firm of attorneys that would have been contracted on brief as attorneys of choice for 63 days, and in that 63 days there's nothing you can point out what they have done except the application for recusal. Okay, 63 days, and you would have known the figures of what goes into that, and so many other things. There are certain things that we're going to have to do better, including the exorbitant price that has been paid to legal reps. That is something that we're going to have to look into. We had no reference. Because part of this, Parliament is not dealing with those. There's a certain institution that is responsible, which is the PPSA, in terms of its role and so on. So there's got to be that kind of coordination so that we know what we're doing, but we have learned out of this process. But certainly, members would have said yesterday, they are worried about the costs that have been incurred as part of this process, and they're able to point out where their worries are. And I've just given you one example. I mean, in the process, you had 3 firms. They were not imposed by Parliament or the Section 194 committee. 3 firms of attorneys: Sianejo, Chani, Mutsueneng Bill, 3 appointed in this. And then you had 3 senior counsels that were part of this. We don't think that that's prudent. And we might have to look into those kind of issues and attend them better as we refine our lessons and as we improve into the next project, whether it is around Section 177 of an inquiry for a judge, which is eminent, or it's Section 89 or another Section 194 project. Thank you.
Thank you, Chair.
Thank you.
Thank you.
Thank you so much.